A pledge of allegiance. Yeah, I got it turned on here. Turn it back on. First item will be a presentation and update by Kurt Spitzer.
Mr. Chairman, members of the Commission, I have a brief PowerPoint presentation, and what I'd like to do is, since there are some people in the audience who are not at the last meeting, is to sort of go over briefly some of the basics on charter government, because I think that's fundamental to our discussion. Then we'll go through the revisions that have been made to the draft charter. And then we'll be happy to respond to any questions that you may have. With me today is Alan Watts, counsel and expert on charter government legal matters. Fundamental to the discussion of charter government for Indian River County is an understanding of home rule, and home rule as compared to Dillon's rule. Prior to the adoption of home rule in Florida for local governments, we operated under a system called Dillon's rule, which basically says that a local government has only those powers which are specifically granted to it by the state, either in the state constitution or in state statute or in special act. So you must have authorization to undertake a particular action before you're empowered to do so. That's the polar opposite of home rule. Home rule says that you are presumed to be empowered to take action unless the state specifically says you can't undertake a particular action. So under Dillon's rule, you look for an authorization. Under home rule, you look for a preemption. I'll give an example. In this, as we speak, moving around the legislative session this year is a legislation that you may have heard of to preempt the ability of local governments to regulate wetlands. There is not specific authorization in statute for local governments to regulate wetlands now, but because there is no preemption, you are presumed to act. There's a bill in the legislature now that would say that you cannot undertake those actions unless your program is approved by the Department of Environmental Protection. So, absent specific authorization under home rule, you're presumed to be able to act unless there's a preemption. The legislature may adopt a preemption this year. We don't know. This changed in 1968. There was a significant revisions to the Florida Constitution. Non-charter counties were granted all powers of local self-government as authorized by the Florida legislature. Charter counties had inherent, directly constitutionally granted powers of a home rule. The legislature came back in 1971 and 72 to authorize home rule powers for non-charter county governments. And there are 19 out of the 67 counties in Florida now that have adopted charters. About 80%, maybe a little bit more, of Florida's population lives in a charter county. And while it in previous years was commonly thought of being something that only the urban jurisdictions or the population in the urban jurisdictions would consider, if you look at the Charlotte, Clay, and Columbia, those are all much smaller jurisdictions. In fact, when Charlotte and Clay first adopted their charters, they were at 80 or 90,000 people countywide. So it's not just something that is of interest to the urban parts of Florida. So in terms of general provisions, let me quickly go through this. I believe it's important to remember that, this is right out of the Florida Constitution, that charters are only adopted, amended, or repealed by the voters of the county. And the word "only" is an important word in this subsection. They're not a creature of the county commission. They're not a creature of your legislative delegation. They're not a creature of the county administrator. They, once adopted, acts as the Constitution for the people of Indian River County. And so there's a couple of example policy areas. We went through this at the last meeting. Generally speaking, the charters cover four primary areas: the legislative/executive branch, and the county constitutional officers, the relationship between the county and its municipalities, and then powers that are reserved to the people, to the citizen, the voters of Indian River County. There are numerous revisions that could be made to the system of governments in Indian River County in any one of these four major policy areas. But the direction that I have heard was that for the most part we want to keep the system, the structure, the powers, the duties in Indian River County unchanged from current practice, with one primary exception, and that relates to planning and growth management. And here, under this area, there's a specific subsection of the Constitution that's worth discussing briefly. For non-charter counties, such as Indian River County is now, in the event of a conflict between an ordinance of the county and an ordinance of a city, the city ordinance prevails within the city limits. However, in charter counties, the charter must provide which ordinance will prevail in the event of a conflict, and this is a requirement of the Florida Constitution. Now, about half of the 19 charters simply say, in the event of a conflict, the city ordinances will prevail, and that's how they fulfill the requirements of this last sentence of this particular article. But there are some charters where the county is given the power to set minimal standards, policies on a county-wide basis. And let me distinguish this from the ability to move people or assets from a city to the county, such as moving fire service or police service from a city or cities via a charter amendment to the county. In that case, there is a separate subsection of the Constitution that does require the so-called dual vote. That cannot be changed by a charter in a particular county. In terms of moving people or assets from a city to the county, there always will be a constitutionally mandated dual vote requirement. That's not what this section here refers to. This section simply refers to the ability of the voters of Indian River County to authorize their county commission to adopt standards or policies on a county-wide basis that are applicable countywide. It's this section that the charter relies on as relates to planning powers. Again, the adoption amendment or repeal of the charter is only via action of the voters of Indian River County. So, in terms of home rule for governments, non-charter counties and city governments enjoy broad powers of local self-government in Florida. Cities and counties in Florida are the envy of cities and counties in many other states. We enjoy very broad powers of home rule in Florida. The difference between non-charter county home rule powers and charter county home rule powers really rests with the authority that is directly granted to the electorate in the county. And in a charter county, the citizens are authorized to determine which government sets policies or standards on a county-wide basis. Is it the county just in the unincorporated area and the cities within their boundaries, or should there be certain minimal standards pursuant to what the voters decide to do that apply on a county-wide basis? Secondly, although this is something that you have not directed us to look at, the citizens are authorized to change the structure of county government, go from 5 to 7 commissioners. The districting scheme could be different. The relationship between the county administrator and the legislative body could be different. But that's not, at least at the present time, on the table right now. So that's a quick little overview there. And I'll go through the discussion draft now, Mr. Chairman, of the current draft of the charter. You've been provided with a copy. In terms of, I guess, looking at it from the volume of words that have changed since the last meeting we had, there is a significant amount of language that has been deleted, both in the section dealing with the powers and duties of the County Commission and the powers and duties of the county administrator. However, let me assure you that those deletions were either already covered in general law or serve to operate as limitations on the county, either the legislative body or the county administrator. There really are no substantive changes from the previous version of last month to the version that's in front of you now. And in the version that's in front of you now, there will still be no significant changes in terms of how either the legislative body or the county administrator operates. And so the discussion draft establishes the commissioner-administrator form of government. The commission, the legislative body, is responsible for setting legislative policy. The administrator is responsible for the implementation of that policy. There is a separation of powers between the two branches of government. The county commission remains at 5 members, elected on an at-large basis, although each required to live in a single residence area, residence district, elected on a partisan basis, required to live in the district during the term of office, but need not be a resident of the district when qualifying as a candidate. You could choose to change that, but the direction that we had was that you were not interested in doing that at this particular point in time. The commission redistricts itself at least every 10 years after the census is done. As in current law, you could do that sooner in an odd number year. Compensation is as provided for in non-charter counties, and this is a statewide formula. That's a population driven formula, both for not only county commissioners but constitutional officers on a statewide basis. You are subject to recall. One difference, this is a requirement of general law for any charter government, city or county in Florida, although the things that you may be recalled for are those that you can be removed from office from. So the criteria under which you may be recalled are not different from those that you can be removed from office. The executive branch, the administrator is the head of the executive branch of government employed by the Board of County Commissioners. The terms and conditions of the administrator's employment may be established in a contract between the administrator and the board. There is a non-interference clause. This clause has not changed since last month's draft of the charter. It attempts to prohibit members of the commission from giving direct instructions to employees under the supervision of the county administrator. It does authorize contact with employees for the purposes of inquiry or referring citizen complaints. It's very standard sort of non-interference language. The constitutional officers are left unchanged. Their duties, responsibilities, powers, the way that they are elected there are no changes to the constitutional officers' positions or authorities. There are some changes in terms of county-city relations. And this is contained in section 1.8 of the charter, and then there was some supplemental language which you hopefully have received in addition to the language in the charter itself. The opening paragraph of this section of the charter is a pretty routine language which basically says, in the event of a conflict with a county ordinance and a municipal ordinance, the municipal ordinance prevails within the city limits. But then there's exceptions to that. And the exceptions are the county comprehensive plan in the rural area or outside the urban services boundary. Its policies prevail even after an area might be annexed by a municipality. Secondly, regulations concerning height in new construction, that policy area is preempted to the county commission to establish ordinances that are effective countywide. Is the county commission required to establish ordinances? No, but the county commission is authorized to establish ordinances in this area on a countywide basis. In terms of the initiative, and we'll come back to this a little bit later on, in terms of the initiative process, citizens are authorized to propose ordinances by a petition process. The process requires signatures equal to 8% of the registered voters who were registered as of the last preceding general election ballot, and that 8% threshold not only needs to be received on a countywide basis, but also in at least 3 of the 5 residence districts within the county. That's designed to try to ensure that one particular area of the county doesn't get 8% of the total number of votes and places a question on the ballot. These proposed ordinances are limited to a single subject and matters that are directly related to the subject. Certain subject matters are prohibited, things that would generally be inconsistent with the Florida Constitution, general law, or other parts of the charter itself. If the correct number of signatures are obtained, it's presented to the Board of County Commissioners. The board holds a hearing. If the ordinance is not adopted, the ordinance is placed on the next general election ballot. If it's approved, the ordinance remains in effect until the next general election, when the voters have time to decide if they want the same legislative body or if they want to make a change. My observation is in other jurisdictions where there are similar policies as this, this is rarely used. We've already talked about recall. The charter cannot change the criteria by which you may be recalled from office. Now, in terms of amendments to the charter, there are really three or four different ways that an amendment could get placed in front of the voters. The way that's not listed here is by a special act of your legislative delegation. The delegation could always propose an ordinance, propose a special act that would be in the form of a proposed charter amendment to your charter if it's adopted by the public. That is a rarely used mechanism. The three most common methods by which an ordinance is proposed to, by which an amendment is proposed to an existing charter is by either the ordinance of the Board of County Commissioners, a petition process, or a charter review commission. The ordinance of the board in the current charter requires that must be adopted by a majority plus one vote of the Board of County Commissioners. The petition process requires, it's a similar process as proposing ordinances, but it requires signatures equal to 12% of the electorate, and not only 12%, but 12% in each of the 5 commission districts. This is what your direction was at the last particular meeting, or a charter review commission. The 12% threshold is, to my knowledge, would be the highest threshold that exists in any of the charters in Florida, if that was adopted by the voters. And then a charter review commission. The charter requires that the Board of County Commissioners appoints a charter review commission every 10 years. It's 15 members. They operate independently of the Board of County Commissioners. Their recommendations, as in most other charters, would go directly to the voters. They have a year to complete their work, and there is a prohibition against elected officials or employees of state or local government serving on the CRC. There are numerous policy changes that could be made to this particular section of the charter, and we discussed those at the last meeting. But in terms of the number of people, the frequency within which they meet, it doesn't have to be every 10 years. It could be every 6 years or 8 years. There are some charters that provide that the CRC is elected. There's one charter that does that, which is a very bad idea to do. There are some CRCs that are required to be appointed every 4 years, which is also, in my opinion, ill-advised. But there are certain things that you could consider. One thing I'll mention to you is if you look at the other common ways in which proposed amendments are punched out either from the county commission or by petition. The commission is a majority plus one vote. The petition process is a 12% requirement in terms of signatures. Those are rather high bars. CRCs, in the absence of language in the charter to the contrary, will typically and even if there is language concerning their rules, will adopt rules governing their operations when they first begin to meet. It's common for their rules to require some sort of extraordinary vote that they impose upon themselves before they make recommendations that leave the CRC and go to the ballot. You could embed a requirement for a majority plus one vote of the entire CRC to adopt an amendment that get placed on the ballot for the voters to consider. That's not in the charter now. It's something that you could consider. All right, so the planning process, and there was a supplemental bit of language that was given to you in this area. Basically, pursuant to the constitutional powers, the Board of County Commissioners, if the voters approve this, would be empowered to adopt ordinances regulating building height for new construction countywide. The Commission is not required to do so, but it is authorized to do so. And if it does adopt these sorts of regulations, they would be effective within municipalities, or could be made to be effective within municipalities. Secondly, concerning the planning process, the county comprehensive plan, as exists on the effective date of the charter, would prevail in the areas outside of the urban services boundary, even after a city annexed that particular area. And this is similar to policies that have recently been adopted by the voters in Seminole and Sarasota counties. Lastly, in this particular section, amendments to the comp plan, and you can see this in the supplemental language here, are adopted by an ordinance passed by a majority plus one vote of the county commission. There had been some discussion of requiring voter approval of commission actions concerning the comp plan, amendments to the comp plan. Mr. Watts has given you an opinion on that subject. He can address that issue with you later this morning. And with that, I'll be happy to answer any questions that you might have, Mr. Chairman.
Commissioners, any questions?
I just have some comments I'd like to add if it's appropriate to do that now, Mr. Chairman. Yeah. Okay. Under section 1.8, where it refers to in the event a county ordinance and a municipal ordinance shall cover the same subject matter without conflict, is kind of in my mind that could just be a little bit vague. You know, one may say 37 feet, the other says 35 feet. Is that with conflict, without conflict? Is there just a way to tighten up that wording to make it a little clearer? Because I can just see where, you know, some fine lines may debate over if they are similar or not.
I will.
Okay.
We'll try to look at that.
Section 2.3, qualifications in election. This is on page 8 of the backup. That middle sentence, any commissioner who shall remove his or her residency from the district shall be disqualified, et cetera, et cetera. Can we put a clause in there that removed from the residence except for causes by natural forces like fire or hurricanes? You know, if a commissioner's house burns down, he or she has to move somewhere on a temporary basis. I'd hate to have them disqualified for that.
I can look at that. If general law controls in this area, it controls in this area, and I don't know if it does, but
Okay.
We could look at, if it doesn't, if it's not specific, I think you could consider that, but it might already cover this.
Okay. Yeah, and if it is covered, fine. If not, I'd just like to have that in there. The Section 3 dealing with the powers and duties. I know last time we met there was some discussion whether all of the regular county employees would become at will with the adoption of the charter. Right. And the way I read it, it looks like that wording has changed, and now all the county employees will still remain as county employees under the direction of the county administrator.
Whatever the current practice is, that would remain, and the intent of the earlier language was only to capture senior employees, but I since have learned that even in those cases there are some protections that Indian River County affords to those people also. So this just deletes that whole area.
Okay. So the only two at wills currently in here would be the county administrator and the county attorney.
The two appointed charter officers.
And I think it's covered under the statute. All we did is take directly what's covered under the statute, and I think Will changed it. I think when the current department heads leave, then the new ones, I think, are going to be at will, is how it works. I think Will will best address that. We just follow the Florida statute.
It's not that they'll be at will. The provisions of this form of charter government say that the transfer of employees is without examination or diminution of existing compensation, pension, retirement rights, privileges, or obligations existing immediately prior to the referendum, and it shall not adversely affect their tenure, position, seniority, promotional rights. It does provide under the powers and duties of the county administrator that he shall appoint and advise with the consent of the board all appointed department heads who shall serve at his pleasure. So I think anybody that's employed now has whatever protections our existing administrative policy provides for them, which includes property rights, termination only for cause. Going forward, new department heads would be appointed with your advice and consent, but they would be serving at the pleasure of the county administrator, and that might lead to other inquiries later on.
Do we have to give our consent?
I don't like that at all. But I don't
have any choice on this.
I know that. Can I finish?
Yes.
I don't have a choice, but that's one of the things I don't like. I'll be honest with you, it makes it a lot more political, and I don't like it, but it's in the statute.
I've dealt with that at the school board level. I mean, the school superintendent would recommend and the board approve, it put basically the board in charge of choosing the individual who's in charge of finances. And I don't mean it in a bad way, but I'm not an expert in educational finance. However, it was appropriate for me to hold the superintendent accountable for our person in charge of that.
What happens, the positions become a lot more political. There's no doubt, you have a friend that's in finance and you think he's the greatest thing in the world, yet he doesn't know anything about government finance. So I don't like, that's one area I don't like, but we don't have a choice.
What were the specific words? Advise and approve, Will? Could you repeat it?
Among the county executive's powers and duties are to, this is quote, appoint with the advice and consent of the board all appointed department heads who shall serve at his or her pleasure and employ pursuant to appropriation and the administrative code such personnel as necessary to administer county functions and services.
That means we'd be approving personnel.
Department heads only.
That's personnel for me.
Right, yeah.
I don't like it.
I don't like it either. I think I like the setup we got now with the administrator. The other thing I like is when you do get calls from people wanting to get help to get a position, it's just so much nicer to say you've got to go to the Human Resources Department and through the, it really is, and I like the fact that, leave it non-political.
But you're saying that cannot be altered in any way?
I'm saying that if you adopt a charter by ordinance, then Florida statutes, the general law that controls county charters, says that these are the powers and duties of the county administrator, and respectively there are other legislative responsibilities of the county commission, which includes advice and consent to all appointments by the executive for which board confirmation is specified. We don't have the option of changing the powers and duties if we adopt charter by ordinance. I think if you had gone through a charter review commission, there would have been more options available, but going this route, it's very specific as to what the powers and duties of both the administrator and the commission would be.
Yeah.
I think a good example is, let's say you have a big movement. Planning issues are big issues. Let's say, and they're very controversial. You get a group that doesn't like what your planning department head recommends from a professional standpoint. There's a movement against them. So you have, that's a very realistic situation, which I think is very dangerous and makes your employees extremely political rather than professional. And I think it's a real shortfall.
Well, I think, though, on the other end of that, we don't have to approve or give consent, or you don't have to get our approval to keep an employee once they're hired. It's still, they work for you, and it's your will, not for the commission. Kurt?
If I might, I think on this procedural problem, one thing that could be investigated is, does the fact that this charter is being proposed by a Part 4 process forever lock the citizens of Indian River County into this particular system? Or, once the charter is adopted, or perhaps even simultaneously with the presentation of the charter, could an amendment to the charter be considered to remove the requirement of consent? I don't know the answer to that, but
I think
there are several charters that have been adopted by a Part 4 process. They don't forever stay untouched. The voters amend the charter.
But I don't believe you can have an amendment that's inconsistent with general law, and changing that provision of general law, I think, would give rise to an inconsistency. That's just my off-the-cuff opinion. I appreciate the thought, though.
Yeah.
Okay. Section 6.1.3 and 7.3.2 both refer to changes by petition. And under the section of the limitation on changes by petition or initiative, it talks about the budget, debt obligations, salaries of employees, collection of taxes, et cetera, et cetera. Can there be additional wording added in there that changes to the powers, duties, and functions of the constitutional officers is also excluded from petition changes?
I believe that, I think that you could do that. I'll look to Alan here, but let me answer that in two different ways, because you're talking about two different processes here. One in sub 6 is ordinances by petition, and I believe that this already prohibits ordinances by petition dealing with the constitutional officers. But your real question is really amendments to the charter by petition.
Okay.
And or the real effect of that question is that I would think that you could do that. It is a limitation. I think that you could do that. I don't know of any other charters that have a similar prohibition as that in order to affect a change that in the future, if this was inserted into the charter, there would have to be a two-step process. One would be to remove in one election this prohibition and then come back at some other time with whatever the initiative subject dealt with. I think you could do that.
Okay. I guess my intent is to provide as much protection to the constitutional officers as we can to preserve their powers and duties and functions, et cetera. On the Charter Review Commission, every 10th year, would it make sense to go to every 8th year and do the timing so it would fall in with presidential election cycle so that there'd be a larger voter turnout?
That is what some charters do, and it's the 8-year frequency is at least in part chosen so that the recommendations will be on the presidential election ballot. You could sure do that, right? Okay. 10 years is the outer limit in terms of practice. The shortest time, which is I think ill-advised, is 4 years. But there have been other places that have went from 4 or 6 to every 8 years, so they could time it with the presidential elections. Okay.
And then under the scheduling, the 2 public hearings, 10 days, 20 days, and all of this beginning no later than July 1st, does that schedule, allow, by beginning the process on July 1st and the 18 months and all that, does that allow it to be placed on a November ballot, given the 90 days the supervisor election needs, and does all the timing fit? Okay.
Yes.
And then any proposed amendment changes by the Charter Review Commission, is that all of them go on the ballot? Does a board have any option to say, well, we want these 3 but not this one? It's a complete deal.
The Charter Review Commission, as this is presented now, is an independent body. You appoint the members. You can communicate with the members, but they're at the end of the day, their final actions are not subject to your operational rejection or amendments. You certainly could publicly let your opinions be known of the recommendations of the CRC. They are not bound by a single subject rule. They could package everything into one amendment, although in practice that I've not seen that done, or they could punch out several individual amendments, or they could do no amendments.
Okay. I think that's it for most of my comments now, Mr. Chairman. I think when we get into the subsection 1.8, we'll probably all have some more, but for now, I'll pass on.
Any other questions, Commissioners?
Well, I might mention this. In addition to the planning supplement that was sent to you yesterday, there was a housekeeping change to subsection 3.3 dealing with the powers and the duties of the county administrator. This was an oversight. I intended to include this in the draft charter that you received earlier in this week, and we did not. But it's just for the record, we're recommending that this revised sentence be added to the beginning of subsection 3.3.
What sentence is it?
What sentence is that?
So, it's contained in a memo that I sent to the Commission on the 10th, and I'll read it.
What page?
I assume it's
the back of the first page.
As revised, the sentence would read, "The county administrator shall be the head of the executive branch of county government, shall have the executive powers and duties that are now and that hereafter may be granted to the county administrator by the laws of the state of Florida and this charter, and shall be responsible to the Board of County Commissioners for the proper administration of all affairs of the county.
If you said and or, because it appears that you almost have to have both of them in line in order for that to be a true statement. By the state of Florida, and this is charter, and if one has it but the other one doesn't, shouldn't it just say like and or this charter?
I don't see any heads. Well, we'll try to put that in.
Okay.
And in that section, do we need to refer to our county ordinances, or is that redundant, or?
Well, like your administrative code, I believe there were other parts of Article 3 that did that, but I think that could be done to refer to the process and authorities as provided in your administrative code.
Okay. Okay.
Anything else, Commissioners?
Why did you revise that?
Beg your pardon?
Why did you revise that?
Well, this basically tracks, we had deleted significant subsections of both the powers and duties as relate to the county commission and also the county administrator. If you look at the,
So this just simplifies?
This is just part of that whole package. It was just an oversight that it was just missed.
Okay.
Okay, if there's no further questions, we have public comment. Anyone from the public like to be heard or comment on this? Mayor?
Good morning, Tom Cadden from Indian River Shores. I appreciate the workshop and appreciate being here. And since I was very tardy with my paperwork that I turned into you today, I would also ask that try not to follow my lead, and hopefully we can get this information before 9 o'clock in the morning when we've got a workshop. I am still concerned, and have had several conversations this morning already, and apparently we do have a difference of opinion between attorneys, which is not surprising. But 1.5 was of a concern to me, transfer of powers. During the first workshop, Mr. Titzer said that we had constitutional protection for both assets and people movement between the municipality and the county. He's repeated that again this morning. I've had two attorneys disagree with him and say that the Constitution doesn't per se give us that protection. And therefore, I've asked for dual referendum protection, and I submitted the language to you. I apologize last night, late yesterday afternoon. I have a new concern now at 1.8.
Mr. Cadden, or Mayor Cadden, and Mr. Chairman, if I could, just kind of ask a quick question. Can you take that out of a little less abstract form and give it in sixth grade language?
All right. It's been a long time since I've talked to a sixth grader, but I'll try. We have, as most of you in the room know, probably the finest public safety department maybe in the state of Florida. And our town is very proud of it, and our town pays for it, and our town expects that level of service. We're very concerned that under charter, not under this commission, because I've had all the assurances in the world this commission is not interested in doing anything like that. But you got to remember, you're term limited and you're voter limited. And the next group that comes in may see things completely different, and therefore I want protection for our town with respect to the public safety department.
Your fear is by ordinance we could take that away?
I've been told you could actually do it without an ordinance or without changing the, I'm told that you can actually change your comp plan and force it through changing specifications and standards for public safety. And this may be a little ludicrous, but, and I'm not proposing this, but I'll use it because I've heard this type of conversation. We have a small town. We have no tall buildings. You might say that our fire equipment is not sufficient for the county needs, and therefore our fire department would be taken over by the county. Now, that's far-fetched, I understand that, but that's some of the concerns that are going around our town, and they're very, very concerned about it.
I understand. I mean, you look at it from, if we could put our emergency services district millage over the top of y'all's values, it would be a windfall for the county.
That's exactly right. Our millage rate is less for providing those services than the county's millage rate is for the same services.
If I could ask, and our attorney here is Mr. Watts, but my understanding is, Tom, and we talk, well, my understanding is what Kurt has said, that this is covered under the Constitution, but is there a way to make that even clearer in the charter?
Gary, this is going to come down to, if I could interrupt you, and I obviously have, this is going to come down to what the lawyers say. I mean, I can't understand. I can appreciate what he says to me up at this podium. I appreciate, I'm not being disrespectful to the Spitzer. They have their opinions. Our attorneys have their opinions. We're going to have to get them together. I can't resolve it with your attorney without my attorney, and he's not here. But, you know, I'll be glad to listen to it.
Well, but what I'm suggesting is finding a way to make it even much clearer, more specific.
Well, we'll have to, because I can assure you our town is very serious about maintaining its public safety department. So if we can resolve it between the lawyers, that's fine.
Okay.
But we need assurance that it's going to happen. 1.8 bothers me based on what he said this morning. 1.81, urban service boundaries. I know what the efforts are now, and I know what this commission wants to do. But again, future commissions might want to do something else. And I'd like to see some language in there that says if heights and densities are changed and they're increased over what the municipalities' comp plans call for, then the municipalities will rule. In other words, a future county commission could, if I understood him correctly, could come in here and change height regulations, and then that would supersede our height regulations, and I don't think anybody wants that.
I agree, and my position all along on this is any increase in heights or densities.
Yeah, well, you and I are on the same page there. No question about that. And lastly, when it comes to the Charter Commission review, again, Mr. Stitzer said this morning that elected officials can't be on it. I'll take him at his word. But I would like to see language in that section that said each municipality is represented on a Charter Commission. You folks have the power to pick the people on a Charter Commission. In other words, someone from Indian River Shores ought to be on it, someone from Vero Beach ought to be on it, etc. And that's my comments. Thank you very much.
Thank you, Mayor.
Kurt, does that elected officials apply to the municipalities, or does it just refer to the county elected officials?
It's city, county, and county constitutional officers is what that is intended to apply to. Now, you could change this section to require that there is at least one resident from the different cities within the county. And I don't know what the population difference is between the unincorporated area and the incorporated, but you could have something like that in the charter if you want.
And this would also prohibit then like city managers, because they would be employees.
Sure would.
Okay.
Right.
Yeah, I think I like that you would include at least one resident, and probably most of them would be from the cities, but I think that would be a positive.
Not to debate this, but just so we're clear about what we're talking about on the transfer of policy versus powers. The constitutional mandate is that there is a dual vote if a charter amendment is put in front of the voters that would attempt to move a public safety department or people or assets. That vote occurs at the same election. It's counted in two different ways. One, the amendment has to pass countywide, and secondly, it has to pass within the city limits of the city from which the asset is to be transferred to the county. That's different than authorizing the county to set some standards or minimal policy on a countywide basis. Here, the minimal standard affects the public. It's some environmental protection matter, or in case in point, planning policy. In these cases, the Constitution only requires a majority vote of the county-wide voters. So to authorize the county commission, and by the way, again, this is done by the voters, not by the county commission. If the voters were to authorize you to set standards, policies, countywide, that's a single countywide vote. If the voters were saying, well, we really think that there should be, a countywide police department or fire department or something like that, that would require the dual vote. Now, what the suggested language here is similar to that which is in the Pinellas County Charter, which, by the way, got into the Pinellas County Charter in sort of a roundabout way, which I'm happy to talk about because I grew up in Pinellas County. I've staffed a couple of their charter review commissions. But that language attempts to impose a dual vote requirement on any amendment that affects city, county policies, programs, assets, people. That has never been tested in court, and I think there's an argument that the Constitution would prohibit that sort of a policy to be embedded in the charter. But that's just for the sake of what that is. Those are what the two different kinds of issues that we're talking about.
Okay. Mayor,
Thanks.
did you want
I don't want to get into a debate, but I did look up, there's a settlement in Pinellas County on dual referendum, and I have the settlement here if anybody'd like to see it. And Pinellas County stipulated that dual referendum is legal. They also stipulated that they will not attack the dual referendum segment of their charter in court again. And if you'd like a copy, I have it with me.
And that dual referendum, again, the mayor, is only on the shift in allocation of personnel or assets?
I think it's on more than that. Anything, but listen, our lawyer will meet with your lawyer and talk about this. I guess that's the best way to put it.
Mayor?
Tom White, City of Vero Beach. I'm sorry, since we're talking about dual referendum, I had to say a couple things. What we'd like to see, and what I personally would like to see, is that anything that affects the municipality, any ordinances or anything that you pass. Now, we're not talking about a dual referendum for the charter itself. Got to be a countywide election, but any amendments or anything that will affect the municipality, allow the municipality to vote if it's going to affect them. Just say, yes, we want it, or no, we don't want it. And that's all we're asking for is a dual referendum. And everybody's got to vote on it anyway, but we want the votes of the city, the citizens of the city, to be able to determine their own fate. And that we indulge the county commission to look at that very heavily. Any questions, Wes?
No, I'm just thinking that it's about what I think Felsmer is asking.
Yeah. You what?
I just think that's about what Felsmer is asking. Is for the city to be able to determine.
Well, what affects one city will affect them all. So what you're trying to do one way is going to hurt the other four. So that's the reason why we need to have dual referendum.
Mr. Higgs?
John Higgs, Indian River Shores. It's good that I'm able to agree with my mayor. He made 3 points. I think they're all very valid, although there's a complication with one of them. First, height restrictions. The mayor wanted to be sure, my mayor wants to be sure that you people could not increase height limitations in Indian River Shores. I think the language as drafted now makes that clear. It says nothing in this provision shall restrict a lesser height restriction. So I think that very valid point has been taken care of in the draft, and I certainly support that. The second point the mayor made was that a charter review commission should have at least one representative from each municipality. That is self-evidently a good idea, and I think I saw the heads bobbing up there, and that all seemed to be right. The issue that's more difficult to deal with is dual referendum. Personally, and I think as far as the people that I have talked to that are members of the Indian River Neighborhood Association, we think dual referendums are a good idea. And I think a very strong argument can be made that they are legally permitted. But there is two different issues. One issue is the transfer of powers, and that clearly is permitted under the Constitution, and it's clearly a good idea. And so the big thing that Mayor Cadden talked about can be put in and should be put in. Transfer of powers, taking over the public service and things like that. Transfer of services. You can do that by dual referendum, and you should, in my view. The other issue is, can dual referendum be required for comp plan amendments? There is a legal issue involved there. I'm not an expert on Florida law, but it seems to me a very strong argument can be made that that is permitted. But there an argument, and the only case that has decided that issue or addressed that issue directly says that dual referendums are possible. But the Florida Supreme Court has not addressed the issue, and law professors can raise arguments that maybe there's an issue there, and there might be an issue there. I'm not claiming there isn't. It would seem to me that a very good idea to have what Mayor Cadden asked for there also have dual referendum. And if for any reason a court said that that is not enforceable, which I think is unlikely, but of course since the Supreme Court hasn't decided, then come up with a fallback provision, such as it can only happen if the Board of County Commissioners approves it unanimously, something like that, which would give the municipalities exactly what they asked for, or as close to as possible. First, give them exactly what Mayor Cadden asked for, and if any reason that isn't able to come through, then put in a backup which makes it as close to bulletproof as living and breathing human beings can possibly get. I think these are all very, very good ideas. Of course, we do have the problem, which the Commission hasn't yet addressed, about comp plan amendments beyond the urban service line, but that hasn't been addressed by any of the other speakers, and so I'd just like to, at this point, to say my complete concurrence with what Mayor Cadden had to say. I think that you have the ability of doing it, and you should do it. Thank you.
Thank you, Mr. Hicks. Jason?
Morning, everybody. Jason Nunnemaker, City Manager, City of Fellsmere. Good to see y'all. Just a comment and a question. The question first, I wondered if it would be possible to apportion the CRC based on district. The logic being that I would think the districts you all go through an apportionment process there anyway, so we'd hope that would provide some equal representation should these go forward. We would just ask y'all to consider that and maybe give some input to the respective councils on the appointments. I know the statute dictates y'all have the sole authority for appointment, but we'd like, I think, the cities to have some say on that as well. The comment would only be that as much acrimony as this has engendered, I think it's been a great process. And that kind of came to me when we were at the Taxpayers Association waiting in this long line. That was good to see, and I think a lot of people are getting educated on issues that they otherwise wouldn't take the time to do. So regardless of the outcome, I think this has been a good civic process. So we're enjoying it.
Okay. The other thing, I think Jason has a good point, and I know with P&Z, for instance, we appoint people from our district then to a large, but it might not be a bad idea to have a representative from each city, and then if the commission's appointing, would each appoint two, theoretically. You'd appoint one from the city in your district or whatever, and then you'd appoint one from your district. So you would have coverage countywide by the 10 people, or how many people?
15.
15 people on that, I think, and then maybe 5 at large. Something of that nature, to have it spelled out that way. That way you'd have complete coverage of the county. It would also tie in with what we're talking about, the 12% from each district. It just spreads it out even more, and you get the different philosophies from the different areas.
Yeah, I'd be very much in favor of that 5 of the members be nominated from each municipality, 1 each from the county districts, and then 5 at large or something like that.
I think that's,
Could that wording be put in there? Are we authorized to do that?
I believe so. Could you repeat that?
I think just wording of the 15 members, 5 of those members would be nominated from each municipality, so that gives them the ability to nominate who they want to be on there.
citizen from each.
Citizen, yeah. Each commissioner would nominate 1 person from their district, and then there'd be 5 members at large.
I think you could, you're permitted to do that.
Okay.
Okay. Thank you. Somebody, Mr. Williams?
Thank you, Mr. Chairman and members of the Commission, and thank you for your diligent efforts to continue. John Williams, 1535 Smuggler's Cove. Just a couple of comments. The provision which requires 12% of the electorate in each of the 5 districts. I understand the motive for that. Obviously, you want to avoid what otherwise could be maybe less, not frivolous, but less important issues to be generated by the general public. But I'm concerned about the criticism that we already see a lot of criticism coming from those who feel that this is not the proper move for the county to take. And Brevard County, for instance, has 4% from each district as opposed to 12%. And your attorney indicated it was the highest that he was familiar with. People are going to say, well, critics are going to say, you trust the people to vote on whether or not our future planning should be such and such. And you want it in the people's hands, and that is correct. But then they're going to say, well, if that's the case, how come you don't trust the people when it comes to petitioning for changes down the road 8 years or 10 years? And I'd hate to see that kind of criticism lose us some votes for what I think is the correct process for the future of this county. I wish you would maybe consider that, at least meet them halfway, or at 8% or 6% or something more palatable and open to less criticism than the 12%. The criticisms that I see, and I know they're not reflective of the populace at large, or I feel they're not, but they're coming, and they're going to get worse, and they're going to get heavier in the effort to defeat this purpose. And it kind of, in a way, amazes me a little bit, having grown up as a youngster in New England, where town meetings were still and are still active, where everything for a smaller city is done at a town meeting, including budget and everything else. There seems to be, I know it's more ponderous and more difficult the larger the community, but it's discouraging to see that so many seem to think that the average citizen in Indian River County is not going to weigh future issues with reason, sense, and foresight. Of course they are. And it disturbs me that people seem to think that folks that live here are not going to have good judgment. I agree totally that this is a very unfortunate thing about the advise and consent element. And it doesn't make sense for the very reasons that Mr. Baird and many of you have spoken about. It flies in the face of what we all know is not good sense. It should be totally void of any political interference whatsoever as far as the department heads are concerned. And it seems to me that the legislature of the state would concur with that if some effort could be made over the next few years to correct that and then allow this particular provision to be changed. It does not seem to make sense that should be overriding what the people here would want to happen. In the interim, with enough public awareness, you could act. It seems to me it's a voluntary thing. If you 5 people and future commissioners say, well, I don't want to advise and consent on any appointments for department heads by my administrator, then, you could make it well known enough so that election time or whatever, a statement could be signed saying it is not my intention to advise and consent the administrator's choices for department heads. And if somebody didn't want to sign that, it would let the electorate know pretty much up front that he had a political agenda for interference. That's, a little cumbersome, but something to clarify that issue so that couldn't be used as a red herring. The concern from some of the cities that the future commissions could get charter review commissions to change the charter to allow height increases in this beautiful county is not really it doesn't make much sense. The reason, we all know this, the reason that this county has set a mark for the state of Florida that's unparalleled is because the citizens of the city of Vero Beach 30 years ago saw the handwriting on the wall, and as a chartered city, had their charter changed so that high-rises could not go up on the beach and a height limitation could be maintained. And nobody has come in 33 years and tried to convince anybody that the people in this community would agree with 3 votes or a charter change that would change that. And I don't, no matter what the developer pressures down the road, I don't see that happening. I think a charter for the county would not be open to any changes that would affect height limitations, either in the unincorporated area or in the city. And the dual referendum issue, while I can understand very much the concerns for transfer of services from a community that may have a higher level of services than the unincorporated area, somehow it has to be managed so that what we know will happen in Fellsmere will not happen. And that sounds to me like a dual referendum would apply, as has been mentioned up here, that would almost give Fellsmere a veto power over any control, and thus the county would be ruined, because it would be ruined. We all know that. It would exactly go the way of Port St. Lucie and Palm Bay. And so somehow dual referendums should not give Fellsmere veto power over the future of every citizen that lives here now and wants to come here. Thank you.
Thank you. I got a question. Then Nancy, you've had your hand up. Well, I'm just curious on this advice and consent. And I realize that would be in the charter, but couldn't the commission have a policy? And we have policies now that we follow, but set a policy, not an ordinance or anything, but a policy that says we would not want to be in the position to advise or give advice and consent to the administrator by policy. And then if that did come forward, at least they'd have to go through the public debate about what they wanted to do, which I think would make it much more difficult to do that if a policy was set by even a supermajority vote.
I think you could make it a matter of policy that, say for instance, to adopt a resolution consenting in advance to the judgment of the administrator and appointment of department heads. I think the only issue might be, are you shirking a statutory duty imposed upon you to give this advice and consent if you decide to? But the real issue is who's going to challenge that if it's the right thing to do. Yeah, and we get accused of shirking anyway, so.
This is an area I have some real concerns. My staff has talked to me. It takes a professionalism out of government makes it political. It's the one, I know it's the law where we got to go, but it's the one thing that really concerns me. It makes our staff extremely political, and I think it's a really bad thing.
But Mr. Williams, I think, has a good point. We only have to do this because it's in general law. And just looking at the history of this statute, it was originally adopted in 1974, and maybe practices and professionalism have come some distance in the last 34 years, and the legislature would entertain a change.
But I think, yeah, and that's I think a good move. But I also think that we could adopt it by policy, and at least if a commissioner or commissioners wanted to change the policy, they'd have to go through the political heat to do that and explain the reasons why. And I think it'd be very difficult to address that publicly, to turn it around, quite frankly. And but that would, you know, at least would take it off the table unless somebody wanted to make a political issue out of it. And perhaps in the meantime, they could change the legislation. Anyway, that's my thought. Nancy?
Thank you, Mr. Chairman and members of the Commission. My name is Nancy Offit. I reside in the city of Vero Beach, and today I represent the Treasure Coast Builders Association. I hope I will tomorrow, and I did yesterday. But I find it ironic, really, that we're talking about politics and how political influence would affect staff decisions or planning decisions. That is our whole objection to the charter government. That's nothing new from me, and so you know where my position is. As Mr. Williams pointed out, the disparity between 8% for adoption initially and 12% for amendments thereafter, I think they are valid criticisms of what the county is looking to do right now. Also, on the issues that the citizenry would vote on as opposed to those they wouldn't vote on, whether it be a constitutional office or such, I think that same argument can be made that you would trust the voters in one aspect and disregard them in the next. And no one is saying that the voters are not capable of understanding these difficult issues, but they are professional experts in every area that dispute land planning and legal issues and such. So to expect the populace to be up to speed on these issues, I think is unfair. I think it's unfair to put the onus of their future on them getting up to speed and really delving into what are very complex issues. One of the things also on the CRC and talking about how we would have broad-based representation on any charter review commission. Again, I see irony in the fact that we're pushing this through by ordinance now instead of giving it that broad-based public input that I think it deserves. Let me see here. Again, I think the whole thing is political, not just some of the points that were pointed out. And when we talk about a county and municipality, cities or towns, the very difference that by definition a county is rural, a city, town, and municipality is more urban. So what you're doing is really saying to cities, towns, and municipalities who may choose to have a more urban lifestyle, no, you can't really do that. You're saying that you're protecting the cities and the towns and municipalities, but in effect you're really not. You're making them your own jurisdictions, whereas before they had more autonomy. One of the questions I have specifically is 1.8.2, when we're talking about the height limits. And I agree with Mr. Higgs that, as I read it, a municipality can impose stricter building heights than the county would otherwise allow. But where it says that the county establishes a maximum permissible building heights for new construction, what about redevelopment areas such as the city of Vero Beach and other places? Or what about, are we making existing structures non-conforming by this because any redevelopment efforts or in the case of a hurricane or destruction, that would be new construction, at least as I understand it. So I would like to see how that's addressed, please. And I don't know who this question would be posed to, perhaps the consultant, but at what point do you consider expanding the commission? Say now we have 5, we talk about 5 to 7. Well, thank you. Those are my observations. I appreciate your time. Thank you.
Well, I think, Nancy, if the charter does pass, then expanding from 5 to 7 would either then be done by a petition through the Charter Review Commission, or the board could propose that as an amendment.
Right, but I don't, has there been any thought to going into the charter with 7?
Not that I'm aware of, no, ma'am.
Are there, I wonder if we could ask the consultant if other counties have done that, or what are the benefits? I just see, I won't hide it, I just see that there's such a concentration of influence, frankly, among you, that I would like to see broader representation in the county. Thank you.
I think if I understood what you're saying about influence, but I think we have a pretty diverse voting record here.
Well, I think you used to.
I think we still do. I think we still do if you go back and look at the meetings. In fact, I think that this situation in front of us is quite diverse. But I would also say, as one commissioner, and I've heard the criticism about not taking the 18 months and doing the charter committee and so on and so forth. I can tell you that, and I'm going to be meeting, I hope, with Jason tomorrow, but I would be amenable to saying, you know what, pull all the annexation off the table, and we'll pull the charter back and form a committee, and we'll take 18 months. But you leave the annexations off the table until we go through the Charter Review Committee and get a charter that could be adopted, and then the race is on again. But we were put in this position because of the pressure, because of annexation happening. And 18,000 acres and then more besides that is a sizable amount.
I believe we're putting this pressure because we're talking about the charter.
Mr. Dudley?
Thank you very much. My name is Don Studley, and I live in Vero Beach in the county, okay? But I do a lot of business in Fellsmere. And I think what the misnomer here is that Fellsmere is annexating all this property. They didn't go out and solicit these people to come and annex. When you brought up the charter, they ran and they said, listen, we want to go someplace we're protected. We've had this land in our family for 200 years. Now we're going to have somebody from New England that lives on the beach tell us we can't do this. And we have somebody else over here up by Sea Oaks that says, hey, we're part of this action committee, the beach people, and they're going to come over and say, you can't do this. You can't have a place in downtown Fellsmere that's going to have 2 stories or 3 stories. Just because they don't want it, that doesn't mean, that affects Fellsmere, it doesn't affect them. And all this is affecting me personally, as well as Cheryl, which is part of the city council member, Jason, anybody that lives in Fellsmere and does business in Fellsmere. And I have brought this up over and over and over again. You people, by virtue of this charter government thing, fiasco, you're asking Jason to take off these people. He doesn't care. He's not the one that wants it. The people want it. Total disregard. Pat Corrigan and all those people, they want to make sure their property is protected. And I don't blame them. I have investors, as I mentioned before, that's willing to come in and spend anywhere between $5 to $10 million in Fellsmere. They're afraid to death to do it. I had a customer, a client, that wanted to do the 87 acres to go out there, and bam, they backed away in a heartbeat. $6 million sale. The downtown area, we're trying to rejuvenate the downtown area. But now we have 73% Spanish people, and we're trying to get lower income housing out there so we can get other people in. I don't need somebody. Actually, I'm from New England. I'm from Chatham, Massachusetts. And town meetings are great, but it only is good for the educated people. The majority of people right now, out in the street, not in here, out in the street, haven't got a clue what charter government is. Not a clue. And the things that y'all are talking about right now, and they're taking notes for the Press Journal, they don't put it in there right. Nobody understands it. They don't know. You know, I talked to Gary 2 days ago, and I said, listen, why don't you people hire a liaison that can sit down with these damn reporters and explain really what's happened? So they come in here and they listen to it, and they can go back and print the truth. I said, 2 days ago, I said, you know, you ought to get together with Jason and Cheryl and all the rest of them and have a meeting. Right, great idea. It shows up in the paper today. There's a meeting tonight at 7 o'clock. I didn't have a clue. Nor do people in Fellsmere, and most of them won't understand what the hell you're talking about because they don't speak very many English. But the people that do care.
And I think our meeting is in Sebastian. I don't think it's in Fellsmere.
No, there's one in Fellsmere at 5 o'clock.
Yeah, but that's about, that's
It's
not
7 o'clock. It's at 7 o'clock tonight.
Yeah.
No.
The
Paper's wrong.
No, the paper is correct. There is a meeting in Fellsmere, and we are all scheduled for a public hearing on workshop on charter government tonight in Sebastian at the same time as Fellsmere is holding their regular meeting.
That's wrong. You're 100% wrong. And here's the city council member right there.
The meeting in Fellsmere is at 5:05 this evening.
There is no meeting in Fellsmere?
5:05 this evening. And it's to talk about...
well, in the Press Journal, in today's paper, it says it's at 7 o'clock, all right?
Well, but it said
and the public's invited.
Yeah, the paper was wrong.
Right.
I rest my case about the Press Journal.
I think we're all in concurrence with you there,
it.
Mr. Studley.
Yeah, Lamar didn't do it. Lamar didn't do it.
No, that's why I sat next to him so I could make sure I got my stuff right. But anyhow, once again, like I said, as far as the general public is concerned, they think it's tonight at 7 o'clock in Fellsmere. So, I guess what I'm trying to say is, I don't understand, if everything was going right before, why the change? There's a lot of anti-sentiments out there, and you're not going to go from place to place to place and talk to these people. You're going to have the separation again. You're going to have the beach against the west side. Regardless of how you treat it, that's the perception. And what we're dealing now is perception. And I think that whoever brought up the fact about districting, Wesley is in our district. If he feels it's right, I think it's great. If somebody else, if Sandra's over on the beach and she thinks what's on the beach is right, that's fine. But don't tell her to come over where we are and tell us what the hell to do. I mean, it's not fair, it's not right, and it's costing everybody a lot of hard feelings and a tremendous amount of investment money. Tremendous. You haven't got a clue how much investment money that's going down into it. You know, so you need to think about that, and I'm surprised there's not more people here. Anyhow, that's it for me. Thank you very much.
Thank you.
And I'm going to take my thing off the agenda on Tuesday, Joe, because we're doing this now.
Okay, thank you. The thing I would say, too, is, you know, right now, Fellsmere has 8 square miles, and most of it's vacant land. And you can build a pretty good city in 8 square miles. Or even if they want to annex a few thousand more acres. But, you know, they're 18,000, and they're looking at more. And 173 people voted in the last election. And that 173 people that voted in that election creates a situation where 3 people on the city council in Fellsmere can change the whole face of Indian River County. And something that Indian River County's been opposed to, we're getting squashed from the north and the south. We were in Palm Bay last night. They're looking at, they've annexed thousands of acres, 102 square miles, and they're looking at 350 to 400,000 people at build out. So, and I would, you know, if there was a way to approach this differently, I'd be willing, and maybe we can come up with something when we speak tomorrow with Jason and see where that goes, or even tonight. So, any other? We got to take a break for captioning. We'll take a 10-minute break.
Right now?
Sure. call the meeting back to order. And
Thank you.
there was
We're missing one.
we're still under public comment. Is there anyone else that would like to be heard on this, Mr. Christopher?
Good morning, Commissioners. George Christopher, Vero Beach. A couple of comments on the charter and then one comment on timing. Firstly, I strongly endorse and support what Mayor Cadden and Mayor White requested. On the provision, the supplemental provision that's before you on section 18.1, which deals with the development outside the urban service line. The draft is before us. I'd ask that it be looked at carefully by Mr. Collins and Mr. Keating and make sure that it's, well, two things. One, it seems to be applying to any comprehensive plan amendment, and the only comprehensive plan amendments that it should apply to is those that change the land designation in the rural lands. And that should be clear. And
can I ask you a quick question on that, Mr. Christopher? If you change the land designation,
yes, sir.
I'm thinking of some enterprise gentleman out there that would leave the classification as agriculture, but bump the units up to whatever they want and still have the same classification. I mean, and maybe I'm just arguing semantics, but I think that people are going to get very, very smart the more we try to box them in.
Well, that's why the language has to be, the language here talks about just moving the urban service line, and what we should be talking about very specifically is changing Ag 1, Ag 2, Ag 3 designation to increase the number of units that can be built.
Okay.
That should be made clear, and I would hope that Mr. Collins and Mr. Keating will.
And I get kind of, piggyback a little bit upon, changing the urban service line. According to our comp plan that we used to have, a new town was not an expansion of the urban service boundary.
That's correct.
And so, I mean, what would be the difference in starting urban services on the outside and moving them to the city limits versus just going straight to the city limits? I mean, this is like nailing jello to a wall if we're not careful, I'm afraid. But
well, I think it shouldn't apply to any other kind of amendment. And keep in mind, by state law, the referendum requirement can't apply if it's less than, or if it's 5 or less plots. Parcels. 5 or less parcels. So that even amendments that are affect density, if it's less than 5 or less parcels, then it won't apply. And I think there should be a provision inserted that if the referendum provision is not enforceable under Florida law, then there should be a backup. And the backup should be either a supermajority of the commissioners or a unanimous commissioner vote. With the backup, if the referendum doesn't apply, either because of the 5 parcel restriction or for any other reason. So, while what you have here is we support, I think it has to be made very clear. Second of all, what's not covered here, and we think you should consider covering, are lands inside the urban service line in the incorporated area, in the unincorporated area, if there's to be any increase in the densities over and above what's permitted under the current comp plan. And I suggest you give consideration to that and that you debate whether to do that. That would
it would almost be hypocritical if we didn't let the cities vote on that.
It's not a question of I'm just talking about the county lands at the moment.
Well, that's what I'm saying, though. It'd be hypocritical for the cities not to be able to have input on what the county's doing when the county wants input on what the cities are doing.
So that I would urge you to take a hard look at that kind of provision. And it would just apply to zonings over and above what's not what lands are currently zoned, but what they could be zoned under the comprehensive plan. So if you have Ag 1 land now inside the urban service line and it's in an R6 zoning designation, it could go up to R6.
And you want?
Without any change in the process.
And so that could happen without going to voter approval?
That's right. But if you were to go to R12 or R15, then you would trigger this requirement. Let me talk to you about an issue, like the timing issue, which I think concerns, there's concerns about. And the timing issue being whether you move promptly with this or whether you take another 10 months, 15 months, 20 months, what have you. And I've written something out here I'd like to read. Absent another acceptable proposal being put on the table, absent another acceptable proposal, you have to make a decision in the next month or two. You either recommend a charter and allow the voters to decide whether they want the charter and have the right to control the land use planning in the rural areas. That's the decision for the voters. And it's your decision whether you're going to ask the voters that question. They've already said it once in a non-binding referendum. But whether you're going to go to them with a charter that provides that, or whether you're going to let Fellsmere, and maybe that's the better way to go, whether you're going to allow Fellsmere with 200 voters decide how the rural lands are going to be developed. Fellsmere has now proposed annexations. Bob Keating came up with numbers that show 230,000 additional people. This is not a fear factor. This is reality. They will be creating vested rights to build that much in units, at least, assuming they don't continue the annexation. Once those vested rights are created, whether you get the 230,000 people will depend on the developers, not the current landowners, not the Fellsmere land planners, but what the developers want. Yes, you'll be able to influence it. Maybe you won't get 230,000, maybe you only get 200. But the history is in Florida and everywhere that the developers are going to go and push the envelope as much as they can. And vested rights will have been created to 230,000 people at least. And that's without more annexation. So you've got the decision. You go to the voters and ask whether the county-wide should control that, or do you take no action, study this for another 18 months, and let Fellsmere have the authority with its 200 voters. And they lose it too once the vested rights are created. And you have to make that decision. You can't dodge this decision. If you don't make a decision, you're deferring to Fellsmere.
Mr. Chairman, if I could make some comments on that, and I just think whenever I look at this, there's several things that I kind of take a little bit of a different view upon. These annexations that are coming before the city of Fellsmere right now, they're not developers today. They're farmers. That's who's coming to the city of Fellsmere right now. And I agree, we don't have 18 months or however long to sit around, whether we approve this or do something different, regardless of what it is. There's not 18 months to sit still. And we keep talking about the 200 votes that is affecting the quality of life in Indian River County. And I guess I'm a little bit concerned because we've had an organization, and Mr. Christopher, it's an organization that you helped found. And they had the opportunity to get politically active in 2 elections in the city of Fellsmere, and they have not. Not to say that if they would have, this wouldn't be where it is today. But we've got some serious issues that we're looking at and spending time on this morning, and this has been a productive and educational process. But right now we're trying to put crap back inside the horse, and we can't do that without getting it all over us.
Say that again?
Yeah, you heard it. He said it.
And
is that a little bit like taking the dog by the tail?
Exactly.
But let me, on the taking the dog by the tail, Wesley, what would you do if there was a pit bull about to jump one of your children? Would you sit there and say, "Nice doggy"?
No, sir. Absolutely not. No, and they cut the tails of pit bulls off anyhow. What I think we're trying to do here is it's a race to see who can get the upper hand. And I don't mean in a bad way, but typically government doesn't win when it comes time to a race. I don't know, I've got some concerns about, we're talking about how to make this better. And this might not be the time for me to go off on my opinion. But the way I look at this right now is Indian River County is so much different than any other county in the state of Florida. And I attribute that not to a charter form of government, but I attribute that to generations that have come before us. And I'll attribute that to even 5 generations of Davises from right here in this community. And to have the opportunity for the city of Fellsmere to move from where they were to where they may go, I just have to say, wouldn't it be a terrible thing for the city of Fellsmere to become a Sebastian or Vero Beach?
Do what?
Wouldn't it be terrible for the city of Fellsmere to become a Sebastian or a Vero Beach? We're talking about a community that has paved roads for Main Street, but dirt roads adjacent to it. We talk about a community that just moved from a strong mayor form of government, which the qualifications for that position was, just like everybody sitting up here, they got more votes than the other person, to a city manager style of government, quite frankly, that in their fashion that they were at that time could not afford. And the most concerning thing to me was the annexations that they did without having a professional city manager at the helm. And I don't know whether we can stop what's happening. And I don't think the city of Fellsmere really wants what's happening. It's people that are pursuing them now because of what is happening here today. And quite frankly, I have some concerns, and I don't know which way to go. But I'm not sure what we're talking about here today is the correct one.
Well, Wesley, a couple of things. You know, this isn't a sudden thing. Knowledgeable people have been talking about these annexations for well over a year. You talk about the landowners there now. Well, they're good people. Once these vested rights are created, that you're talking about 30-time increase in densities. The values increase here become overwhelming, and the decision as to what will happen will be determined by the developers. And you talk about the family farms, and I don't know what this is correct, but I've been told by people that supposedly know that the major farm there, the big one, is 50% owned by an insurance company and 50% owned by foreign interests. Now, that may not be true. I have no evidence of it, but I've been told by people who tell me that's true. But that's not relevant. What's relevant is who decides the development there. Is it going to be a small, and we're not talking about Fellsmere with its Main Street and dirt roads. We're talking about these annex lands.
And I understand that. And I guess really I would like to draw on history whenever you talk about the future. And I'll take exactly what happened in the city of Sebastian. The city of Sebastian about 5 years ago was really in a rather aggressive annexation mode, changing lands, uses, increasing the intensity of land uses, and that came to a stop. Now, it came to a stop after some land had been changed, but I have a hard time believing that Fellsmere is not sophisticated enough, nor I have a hard time believing somebody telling me that they will never become sophisticated enough to be able to stand up and say, okay, this is enough. We have what we need to be a sustainable community. Now,
I heard Commissioner Wheeler say that he's going to propose to them on Friday that they stand still, not do the annexing until an acceptable arrangement can be worked out for how a decision is going to be made on the land use of those annexed lands, and to stand down while it's determined how and who's going to decide the land use on those lands.
And I think that that's a good way to go. I can't say that Commissioner Wheeler's the right person to do that. I think that this board probably should be. I think that there's some things that we can certainly do. I'd love to see some of the density transfers from some of the 1 unit per 20. I'll just take Presley Ranch, for example. That would fit, those densities would fit very well around the intersection of 95. I think that that's the conversation, the dialogue where we should be spending our efforts. I really do. But, Mr. Chairman, I guess I'm kind of off base, and I'll just kind of hush.
Well, you know, I met with, do you mind if I?
Yes.
I met with Jason Nunemaker yesterday, and he had some concerns that we have partial or misinformation from a staff perspective. And he might be right. We've been trying to get as much information as we can in a very quick fashion. Maybe it would be good for the commission and Fellsmere to have a workshop and discuss their annexations in a nice manner, just to understand what they're doing, because there's a lot of fear of the unknown, discussions about what we're doing. I don't know if you think that would be a good idea, but
suggested doing that when we started talking about charter and having the workshops, you know, and I think they weren't available until like May. I'm going by memory, but I think our secretaries called, and I think it was like going to be May before they were available. And this annexation and other annexation was going on. And as long as I'm speaking, let me say a couple of things. What Wesley said about we're dealing with farmers. Well, my understanding is that Fellsmere Joint Ventures is owned by Sumitomo, which is a Japanese export company, and Prudential Life Insurance. Prudential Life Insurance currently has developments going on and developing land and building houses in other places in the country. Also, they were concerned about being able to build a bridge. They have a 100-acre island to be able to transfer densities. And I think as any corporation that's responsible to their stockholders has done, they're looking to maximize the profit for their holdings. I'm a capitalist. There's nothing wrong with that. But I also, it's not, you know, I'm a NIMBY in this situation. And, but I would, you know, as one commissioner, I would be more than happy to have a workshop with Fellsmere and see what we could come up with. But I can tell you that something needs to put everything on hold if we're going to do that, and it's got to be done legally. Because, and it's got to be binding, that things would be put on hold, because I'm not interested in setting back and allowing charter to be set aside while they continue to annex. And that's one vote here out of 5.
Mr. Chairman, you're right on point with that. Or I guess I don't know about Fellsmere Farms, but I'm not sure what this charter is going to be able to do with Fellsmere Farms. I know that there's other people that are farmers, like the Corrigan family, like the Grace brothers. They're farmers, and they're probably 1 or 2 decisions away from this commission's decision, in a way I should say, from pursuing the city of Fellsmere. They probably got the paperwork filled out and the check cut, just waiting on them to turn it in. If you really, I mean, if I were them. And so that's what I'm talking about with the farmers, is those that truly could be affected by this charter. And again, it's not out of their desire to. They have no desire to call Fellsmere when they need an issue with Ranch and Grove. But that's exactly the direction it's going, and that's what I mean by the farmers, not the ones that have already moved forward.
May I just add one comment, not to put more fuel on this fire? And you certainly should talk with Fellsmere, and you certainly should try to work these things out. But be clear, 3 weeks before the election, Fellsmere was asked whether they would agree to a proposition that all lands, rural lands, would only be developed as approved by the county and all the municipalities. They said they couldn't address that till after the election. We're 4 weeks past the election, and the only response from Fellsmere publicly has been to announce this massive new annexations. Talk to them, but let's not be foolish. You're dealing with the county. Decide that they should, you can decide that they should decide how these rural lands should be developed. That's a good decision if you want to make it. It's not the controlled growth philosophy that you ran on, all of you. I don't think it comports with that at all. Please, leave this decision with the county. If Fellsmere is prepared to stand down and work out something so they have input, certainly. Thank you.
Thank you. Jason, I see you ready to pop up.
Jason Unamaker, City Manager, City of Fellsmere. For the record, both my city vehicle and my personal vehicle are Fords, just in case we're worried about the Japanese.
That wasn't a shot at the Japanese. It was simply a statement of fact.
Well, okay. You know, there's been so many statements that are predicated on false assumptions, and, you know, this is not the first time coming from the Planning and Zoning Commission of the county that these have come forth. There, you know, certainly in the Indian River Neighborhood Association newsletters, you can find errors, purposely so, I would assume, otherwise they'd have been rectified with a notation. But be that as it may, just the assumption we're going off right now, 230,000, that's predicated on annexations that are currently not contiguous. Those properties do not have the ability to come into Fellsmere. That's predicated on annexations that are in some areas going to use the current county land use designation. So it's disingenuous to make the assertion that that's a net addition. The others have been submitted at less than 3 units per acre. So it makes no sense to assume we're going to approve higher than that. The other FJV, the major one we're talking about, the negotiations have not yet been completed. As far as Fellsmere's commitment to dialogue, nobody can challenge that. There is an invitation pending for this county commission to come to the city. That's been with y'all for a while now. Now, I don't want to get in a tit for tat for scheduling purposes, but we can demonstrate that. We offered dates in April and May. Mr. Wheeler, you know Chairman Wheeler, you're welcome anytime, and we treat you nothing but with graciousness and respect.
That's true.
We are a Boston Terrier, not a pit bull. And everybody knows Boston Terriers are nice and fun to play with. But they can get squirrely at times. And I guess we're in that squirrely mode. But we've been pushed there. 2 years ago, I initiated dialogue, or tried to, about a JPA, a joint planning agreement, set reserve areas, do that planning thing. It was refuted time and again we can demonstrate that for the record. Nobody will make the case that Fellsmere has been anything but amenable to a more appropriate public process. If we need to be pushed on that, that's fine. But we're here to work together as a partner. The events that have come to bear are at y'all's action, and I mean the royal y'all. So I don't know where y'all stand individually, but the collective actions of this board have pushed certain reactions. Be that as it may, it's my job to look not at the downside, but look for opportunities. I think if we all work together on these things, there are opportunities for everybody. I think there's room for negotiation. We look forward to a fruitful discussion tomorrow, bearing in mind that each of us, myself and your county manager, has a responsibility to report back equally to the balance of our boards. We've invested no particular authority with the mayor, as I understand y'all have not with the chairman. We're looking forward to that discussion. But what would really be fruitful is to go forward on a factual basis. Making these assumptions that the presentation that was done earlier, it bears no fruit. It's alarmist. It engenders hysteria.
If I may, Jason, you know, you look at the history of something. It's not unusual to look at what somebody's done to get where they're at, to figure out what they're going to do in the future to get where they're going. And Fellsmere in the last 4 or 5 years has gone from 1 square mile to 8 square miles. 2 pieces of property have been annexed into Fellsmere. currently, 3,750 acres to the south, and then the quadrant that we talked about on your comp plan the other day, 392 acres, because the people that own that property wanted something other than what our comprehensive land use plan allowed. And I think our comprehensive land use plan overall was thought out very well. I wasn't a part of the changes that were made, but the industrial property and the things we've talked about. So I think there's probably concern or even a lack of credibility on both sides. And I think that we should get together and talk. But I you know, this isn't a go mode on both sides here. It is a race, as Wesley said. And, you know, as one person, and I'm 20% of the vote here, I understand that clearly. And, but as one person, you know, I'd be willing to say, let's set this here for now, and you set your annexation here for now, and let's start negotiating on something. If this is the pressure to bear that's brought us to this point, that's a positive thing. And I think this has been a good civic lesson. But the bottom line is I would want a legal document that says we're going to set these aside and honor this and negotiate in good faith, as in fact Chapter 171 suggests, and to see what we could do. And I don't know, maybe it's too late for that. I don't know.
Well, I would suggest we seize the moment. Is that the phrase?
Carpe diem in Latin.
Right. And have something else besides the fire igniting more, and see if we can just be good neighbors. And but more than that, be smart neighbors and try to work out interlocal agreements or whatever that we need to go from this point. 18 months is a short time and a long period of time, but right now it sounds like a long time. And if we can get something done quicker, better, let's try to do that. I think we're all here in this community trying to do the best we can with the knowledge we have. And so let's all be gracious and try to work this out and try to do it jointly.
Well, I think tonight we're in anticipation of a well-defined, well-founded, amenable interlocal agreement coming forward as part of the fruits of Fellsmere's meeting. Would that be correct?
Yes, sir. What we'll be doing tonight is initiating a broad resolution. The interlocal agreement itself with all the details will be something to follow, but at least it'll provide the initiating parameters. Now, if y'all want to add to that, I'm sure there'll be a response. You know, we've got areas where we can move and areas where probably we won't move, but it's going to be something we move forward on a mutual basis. I think that's the only way that negotiations are struck anyway.
The reason I recommended a workshop is sometimes we have misinformation and also there's a hysteria, and if they lay it out with both parties there, what they're planning to do, because there's rumors, there's misinformation, and we have we had to look and make some assumptions when we were to do the report, and Jason said some of those assumptions are wrong. So I think if we were to have a workshop with Fellsmere, have their planning people lay out what they're doing, and just so, because I'm not sure we're always right staff-wise, because we don't have the accurate information, and I think it would be helpful to both sides at least to have that form of communication in an open meeting, so we're not all listening to rumors, and that's what concerns me. And also both boards would be there so that you know, when I have to inform all five of you, I might miss something, or there might be something lost in the translation.
And just for further information on the ability to reach out, one of the things I responded so tersely to the comments by the Community Development Director on that land use change was when I got it. We're always available, and we appreciate the opportunity to have dialogue. When we processed or in the process of annexing the Anson 300, which is on the east side of 95, that little sliver, I sent an email to Bob about Mr. Keating to ask what might be the concerns, and he responded back with a whole list of items. Once we were able to establish we weren't going to be changing the land use in excess of what would be allowed under the county's rules, there was a level of comfort there. And that was done after Fellsmere 392 was already in process, but when I got the sense that this was a concern to the county, those are the type of steps that we've initiated. So at no point have we ever been opposed to dialogue. It's when we get into this posture back and forth as far as, kind of out Sun Tzu each other, that we do that. But if we do that, we will do that. If we're put in that situation, we'll be as creative as we need to be. But that said, we're certainly welcome the ladies' comments.
Well, when can we set a workshop?
Look forward to it.
Well, Jason, can you clarify, is tonight's meeting in Fellsmere at 5:05?
Yes, 5:05, and then we're going to party in Sebastian.
And what is the topic of the meeting in Fellsmere tonight?
Initiating the interlocal boundary service agreement pursuant to 171-2.
You have refreshments?
Of course.
Is there a chance?
Do you have bottles of water with the city of Fellsmere?
Fellsmere like
Anything you want.
No, Palm Bay offered to sell you that water.
Do you think you could get some dates, maybe tonight at your meeting, that we could set a workshop as quickly as possible?
Yes, sir.
If you get some dates, Jason, and then I can bring them back next Tuesday. But I think my board, if we did that, would like that as quick as possible, if you wouldn't mind.
And that was going through my mind last night, as informative and as educational as it was to talk to Palm Bay. In the back of my mind, I was thinking this should be the city of Fellsmere. I mean, it was a good education, but we've got issues in our backyard that we need to kind of work on and get some dialogue started that, quite frankly, should have been last night if we could have.
Well, I appreciate it. It gave me time to see my wife, so we're ready in the future.
Jason, do you or Warren have with you or can get us quickly any of the current draft wording of the resolution that you'll be talking about tonight?
Sure, we can email it to y'all. The resolution itself, it doesn't have the exhibits yet because we'll be talking about that. What you'll receive in addition is the map, and that'll set forth the areas and then the geographical areas, and then you'll receive another attachment after tonight that'll say the subject areas where we want to negotiate. And then, of course, pursuant to state statute, you've got 60 days to respond to that, as do the other invited entities.
Okay, great. Thank you.
Thank you.
Mr. Spitzer, if a interlocal agreement is forthcoming and or at least beginning to be initiated into the play, how will that affect the charter government aspect of application?
I think you could move for the time being, on a parallel track, and then at some point in time, maybe part of the one or the other option would be dropped. In Sarasota County, recently, as the city folks I'm sure are aware, they had been moving on a parallel track, and I think that an agreement either was close to or perhaps had been reached, but the amendment to the charter went on to the ballot anyway and was overwhelmingly approved by the voters in the county.
And what happened to that interlocal agreement?
I'm not sure. I don't know.
So we only know what happened with the charter.
The charter amendment, which is similar to what was adopted in Seminole County and which is roughly similar to what you're looking at now, was adopted by the voters of.
Well, my concern is that an interlocal agreement may have varying levels of opt-out or participation levels for each municipality, and I believe that might contradict some of the elements of the charter.
It could. That might be a question for Mr. Watts to address. I'm not sure which one would trump which one if they were both approved.
If I'm understanding what you're asking, Joe, I think the commission would make the decision whether to move forward, whether to stall it, whether to shelve it, whether to whatever, based on decisions made by Fellsmere. And if we could, as I said, freeze everything, hypothetically, but legitimately freeze everything, and continue dialogue and discuss certain things. But I, as one commissioner, unless they're willing to take off the table what they've got out there, I'm not willing to take off the table what we have out here, because this is far too important. We're looking at tremendous changes in this county with the acreage that's being annexed. And I do not believe, and I personally believe, right or wrong, I know what I believe, and I do believe that the potential for Fellsmere to become a Palm Bay or Port St. Lucie is a high likelihood.
The potential for Sebastian, too. I mean, they could go across to the Anson property and go across 95.
Or it's a potential for the county also.
Absolutely.
Without the charter. In fact, when I started thinking about all this, it was to do with the county. It didn't have anything to do with Fellsmere.
Well, let's don't dream up more problems.
Well, and that's a good point. That's a good point, because I think really what we've done as far, and it is your job to look down the road, and I'm not faulting you for that, but I still believe
For that butt-in.
that, well, it's like the movie Click. We've just fast forwarded ourselves 30 years.
Yeah.
That's exactly what we've done, and we've done that by using a big stick instead of by using some dialogue. And I'm not saying stop. I'm not. I'll tell you right now, I'm not in favor, I don't think, of what's in front of us today. But I'm not saying stop. But I am saying it's time for us to not sit back and take a breath.
But let me, Jason, what are the chances? What we're talking about right now in a workshop, what do you think the realistic potential is? Is it we freeze things and work from that point? Is that a possibility from your point of view? And I know you haven't got your council here, you have one council member with you, but is that a possibility?
Well, I think there's certainly possibilities to give you all a great comfort level from what's been presented so far as the 230,000, as far as all those properties that were represented as being possibilities for the city of Fellsmere. What may come off the table, I'd want to confer with council on that.
I realize that.
I think we can have a good dialogue about that tonight. But what I feel comfortable in saying is that any future additions to that slate, and that what is currently in is FJV and Anson, beyond that, I think council, from my discussions, certainly is amenable there. Beyond that, I mean, it's a discussion we can have.
So, but what I'm hearing you say, if I read between the lines, is you don't think that it's probable that the 18,000 would come off at this point?
I didn't comment on probability.
Okay. What were you saying then?
I said that I had a great deal of assurance on future annexations, and the others I'd like to confer with my council on.
Okay.
And I'd like to point out that 233,000 number, I instructed I instructed my staff to come up with a worst case scenario, and so I'm at fault at that. It is not my staff that followed my instruction.
Gentlemen, I have a commitment, and so I have to leave. Absolutely. And I will see you tonight.
Okay, thank you, Commissioner.
Yeah, and Mr. Chairman, I just think, by the end of the day today, between the Fellsmere meeting and another workshop in Sebastian, we might have a clearer idea of where we may or may not be able to go with negotiating with Fellsmere. And this is a workshop, we can't really take any action anyway. So I think, as everybody has said, this has generated some great dialogue, and I think we're finally making progress on coming to a solution here. And we'll just see how today shakes out, and then we'll have a meeting Tuesday, and we can take action at that point if we need to.
Okay. Is there anyone else that would like to be heard, comment on this? Yes, sir.
Andrew Kennedy, 535 Eugenia Road. This is my second workshop. Still confused. Only slightly less than the one before. And anyone who sees my wife, I'm out making deals. I've been here all morning, so I'm trying to educate myself on what's happening.
This is televised,
I know. She's not watching, I can assure you. I think she'd rather try nailing Joe to the wall.
We'll put one of those little fuzzy faces over your on the TV.
Yeah. To me, it seems that it's kind of an abdication of your duty, leaving it up to us to decide what happens. I mean, it's daunting to look at all these agreements. I'm not an attorney, and all the specifics, all the moving parts. It's really, really difficult to digest. And I'm sort of the embarrassing generation, voter apathy, don't turn out, that kind of thing. So it just seems to me that there's a slight abdication there, and it's a lot to understand. And I'm not the urban service boundary, if I talk to one of my colleagues and coworkers or whomever and said, hey, what do you think? They're just going to look at me like a deer in the headlight, and much less discussion on charter, which I'm still trying to understand and convey to these other folks. So from my end, my generation or whatnot, I think there's a lot more that needs to be looked at and understood in terms of ramifications. So I just wanted to convey that. It's, that's it. Thanks.
Thank you, Mr. Kennedy. Is there anyone else who would like to be heard? Mr. Burrow?
Good morning still, Commissioners. I'm Etal Verone. I live in Indian River Shores. Actually, I was going to say some things, all of which have been preempted by what George Christopher ended his comments with. Speed is something you must consider now. It's not in your hands. It's been taken out of your hands by the aggressive moves made by Fellsmere. I will correct one thing that, Wesley, you mentioned. The IRNA did, in fact, want to be involved in the Fellsmere election. But in each instance, to my knowledge, there being three, we were rebuffed. Not all people love the IRNA, Wesley.
Well, and I think that's an interesting point, because
it might be, but it's really not the point that I wish to mention here.
Well, okay.
It's a comment only. What I do want to mention is that we have a lot of discussions. They're intergovernment discussions. And on the one side, there are those who wish to see this go before the people as a referendum, as a vote, on how we'll really carve and create our future. Now, I want to remind you, I leave this thought with you. The one great thing that happened to this county 33 years ago, let's not forget, it was not done by government. It was done by the people. It was done by a referendum. It created height restrictions, which is the very first, and that was in Vero Beach. So for those who say referendum is a bad form of government, referendum created what we have today. I just want to leave you with that thought. I will be up in Sebastian this evening, and perhaps if George is not there, I'll repeat what he said.
Can you come to Fellsmere too, Etal?
I don't think so. I have a cold.
And I just, on that wonderful thing that happened 35 years ago, it happened after the community had the opportunity to see what not doing that would cause.
I think that's parallel.
And
today.
Exactly.
They've seen a lot of stuff they don't like.
And the ability for a community to move from a mile square, I don't know.
That's the importance of the moment, Wesley, and I'm glad you said that. I make a great parallel. The visual evidence of what people are against still stand today. Exactly. They're not occupied, they're being rehabbed. Those are the two towers. If we allow this to continue, we have the real possibility of seeing as much as 230,000 people in the Fellsmere area. So I do think that there is a parallel.
There is, and I don't think there's a commissioner up here, if they haven't said it yet, that they're wanting this to continue. It's the means by which we get to the end. And I think that it's important to realize what's got us here is not a commission that has wanted to expand the urban service boundary because of political positions. Clearly what I think has gotten us here is the heavy-handed approach and the lack of dialogue. And yeah, you can agree or disagree, I'm good with that, but we don't have a charter yet, and yet we've got rampant annexation now.
Well, define, Wesley, a fish doesn't bite unless you've got a lure in the water. Fellsmere decided, and currently have done three things that I think are very important for your consideration. A, they've gone along with an increase in height, at least on one project, at least as I've read it. B, they've gone along with an increase of density, a vast increase of density, from one home on 5 or 10 acres to 3 homes per acre. Now, we know it's going to boil down to 2.6 homes or something like that. And the last of what Fellsmere did, if you look at the record, is that they have changed most recently. This was part of a county commission meeting. They've changed land use designations, which was a very well thought out, comprehensive plan to place industrial at one of these important intersections.
They have not changed. They are proposing to change.
They're proposing to change.
And so
now,
have the city of Vero Beach, if I may. The city of Vero Beach has also raised something above the height limit. The county has raised something above the height limit.
They have.
And the city of Fellsmere, now to go into the density issue, the city of Fellsmere, technically, for the longest in our comp plan, was not even considered inside our urban service area. And because if they choose to expand by an inch, by the very nature of what the county's put around them, yes, they have increased their densities. But it's by the very nature of exactly what's around them, unlike the city of Vero and the city of Sebastian's been able to do, because that land's been inside the urban service area with higher densities.
Wesley, you'll have to live with the decisions that you all make a lot longer than me. I've got much more gray hair than you. But I'll tell you this, it's important for your families. And that's the only reason people like me stand up here before you. I have nothing to gain. I don't own 1 square inch of land around Fellsmere or out in that area. I'm not a farmer. I'm not giving something up that my great-great-great-great-great-grandfather gave me gratis. I have nothing to gain except for one thing. I want my children, your children, and the children of future generations here in Indian River County to enjoy what I think we have that makes us special in coastal Florida. And I believe it's an requirement incumbent upon you to take that in consideration. And I haven't even mentioned other concerns like, how about the cost of what Fellsmere intends to do? I have heard Jason mention on occasion, developers take care of that. Oh no, forget that. Developers will take care of that. You know what? That ain't true, guys. You know it's not true. Highway 60, some time ago, we had some discussions here in this room, and the developers wanted to widen Highway 60. And the discussion at that time was the developers will take over the widening, just as now we're talking about Highway 1, and the developers will take over the widening. But when it really came down to it, I do believe that Joe Baird will bear out. The taxpayers are paying for a lot of that. It's not going to be just a developer-sponsored widening. We're paying for it. Now, it's going to be hard for me to believe that adding the number of people, annexing the amount of land that is being annexed up in Fellsmere, isn't going to cost everyone in this county. And I tell you this, just as someone pointed out earlier, the gentleman in the cowboy hat, the guys up at the moorings shouldn't have anything to say about what's happening in Fellsmere. Yeah, they should. If it costs them some money, if it costs them some lifestyle, they surely should. And it will in both instances. So I've taken much longer, and all I wanted to do was say something that George preempted me on, but I'll repeat that this evening. Thank you so much.
Thank you. Jason.
Just briefly, because facts I think are somewhat important, there is no approval in the city of Fellsmere in excess of 35 feet. That was a fundamental misstatement of fact. And that is in the Indian River Neighborhood Association literature on the website, January 07, I believe it is, y'all have in your newsletter. But it's not true. It's not true.
What about the hotel?
That's what I'm referring to, sir.
Okay.
Now, do we have the ability to grant additional height as a conditional use? Yes. Is that how it's being portrayed? No. Is there an existing right to that as far as is there an application that's been approved for it? No. As far as costs, I guess another whole discussion needs to be had on the ability to negotiate from a vested rights perspective, which is what occurred through the State 60. you were dealing with a methodology that was predicated on vested rights. You could not charge the developers beyond what their pro rata impact was, I believe. We are not in that situation with annexation, but that's a whole nother discussion. And finally, the city of Fellsmere has increased the net usable acreage for commercial industrial, and that's the presentation that was not pointed out the other day. And we'd be happy to make those facts available to you if people are interested. Thank you.
Thank you. Is there anyone else that would like to be heard? Seeing none, we'll conclude. Any concluding remarks from any of the commissioners? We'll adjourn the meeting. Thank you.